Greetings of the day, ma'am. For our Economics of Law CIA, Sufi and I have chosen Monsanto Holdings Private Limited versus the Competition Commission of India. This case mainly pertains to the intellectual property rights which have been laid down by the Indian Constitution and the Competition Control Act of India. Getting into the literature review, Professor Gandhi has given us a brief overview of what Indian intellectual property rights are. And Professor Mishra and Professor Kumar have also explained what industrial IPR is in detail. The Competition Act of 2002 has been completely explained by Professor V.K. Singh, who tells us how written and spoken agreements and arrangements between firms or individuals are all subject to competition regulations. So I will explain what the case is all about. Monsanto Holdings Private Limited is an agro-based company which deals in the export of fertilizing chemicals and also in the research and development of agricultural commodities like high-yield seeds. This specific case pertains to their Bolgar 2 cotton seed, which protects its cultivated crops from the bollworms. Monsanto Holdings licensed this specific technology to Mexico Monsanto Biotech Limited, which is also a subsidiary of Monsanto Holdings. This subsidiary further sub-licensed this patent to three specific seed developers, namely Nuzi Vidu Seeds Limited, Prabhat Agri-Biotech Limited, and Pravardhan Seeds Private Limited. The sub-licensing agreement had a twofold consideration to it. So there was one-time non-refundable fee which was paid upfront when this technology was transferred over from Mexico Monsanto Private Limited to these seed manufacturers. And the second was named as a trade fee, which was a recurring fee, which was determined on the sales volume of these BT cotton seeds made by the developers. As the sub-licensing agreement got expired between MBBL and Nuzi Vidu Seeds Limited, the agreement had to be revised and this trade fee was now recalculated on the basis of the total MRP as given by the operations of the manufacturers. The renewed agreement was executed and soon after there was problem between Nuzi Vidu Seeds Private Limited and MBBL because the recurring fee was not being able to, was not viable enough for Nuzi Vidu Seeds Private Limited. So on July 19th, 2015, MBBL approached the High Court seeking its unpaid dues from the three seed manufacturers, who in response approached the Competition Commission of India, stating that MBBL held a dominant position in the market for BT cotton seeds, and therefore they sought to cancel the patent or change the royalty fee structure in an attempt to eliminate competition in the market. In response, the Competition Controller of India held that there was prima facie merit in the allegations and hence ordered an investigation to be held. Monsanto did not take well to this order by Competition Controller of India and therefore submitted a writ petition before the High Court of Delhi seeking a stay on the CCI order, and hence the judgment was given as such. A single judge bench of Delhi High Court dismissed a petition filed by Monsanto against the CCI pro bono. It was asserted that the concerns arising from their licensing arrangements should be referred to the Controller of Patents and not the CCI because CCI lacked jurisdiction in this regard. Despite the establishment of a specific statutory regulator, the Delhi High Court rejected the petitioner's objections and confirmed the CCI's jurisdiction to investigate such conduct. Now over to Sufi to explain the economic impact of this case.
Greetings, ma'am. So as Suryansh has gone through the case, I will be getting into the in-depth analysis of the economic perspective. So the case helped us understand in significant economic perspectives as charging an unjust license charge and entering into price agreements targeted explicitly at overcharging farmers that use the patented technology of BT cotton seeds. This further speaks volumes about the inequality and the discrimination which follows through farmers within India. Furthermore, charging different prices in different geographic places based on local conditions significantly when such variation is not related to cost, can distort competition. This is an action done by the party. It is similar to third-degree price discrimination practiced by monopolists. Hence, it is a practice in derogatory nature. When we get into the description of the judgment highlights certain overlapping and controversial issues between the Competition Act and the Patent Act, but the judgment reaffirms that the CCI is entrusted with the function to deal with anti-competitive conduct. And to that extent, the CCI can assume jurisdiction even in the matters involving a specialized statutory body. When we talk about the unique observations we made about this case, we did an in-depth analysis between economic factors as well as legal factors. So the first economic and legal factor we would want to talk about is the breach of contract. It is evident that the breach of contract led to inefficient behavior, increasing the transaction costs, resulting in a state of potential market failure. The case clearly describes a realistic situation of increased transaction costs. We as economics students believe that transaction costs should be put to a minimum and there should be no breach of contracts between two parties in order to increase optimality as well as welfare. The second aspect we would like to talk about is the aspect of Pareto efficiency. So in a state of Pareto efficient, the state requires enforcing a promise if the promisor and the promisee both wanted enforceability when it was made. Through this case, we can understand that the aspects of greed and monopolistic drive to go against the optimum situation is present. When we talk about the importance of reliance and trust in a case, we can understand it through an aspect of negative sum game. In an aspect of negative sum game, there is no reliance, there is no trust. But in order to maintain long-term contracts, it is necessary to secure cooperation in the long run. This long run can only be maintained through informal devices rather than enforceable rules. It was shown through the paper that monopolistic party exploited the other party. The fourth aspect and the unique observation which we made was through a lens of agency theory. We would expect Monsanto Holdings Private Limited to uphold their business relations with the seed developers and not breach contract. But then again, it is flawed rationale of decision making to give rise to exceptions and negative outcomes. The case also helps us understand how decision making functions and how corporations go on to make their decisions to favor profitability or losses. The last and the main aspect would be our suggestion into forming perfect contracts in order to deal with such situations, even though it is an ideal situation arising from a theoretical perspective. It should be complemented with trust and loyalty in a business to prevent such a landmark case to go on to such a level to create discrepancy in society. Thank you.